have a feeling that, at first I was flattered. I was thinking, well, they figure I'm going to be so entertaining that at the end of the day I'll be able to keep everyone up, and sometimes that happens. But I have a feeling you're here because you need that one ethics credit. Either way, we're here together for an hour. Let's make the most of it. I want to talk to you about ethics in a slightly different way than I think it may have been brought up in the past. And I'll talk to you about it by simply agreeing on a few basic rules. First of all, you really can't teach ethics out of a book. And most problems that people have with ethics have nothing to do with their lack of familiarity with the rules. That's not where people get into ethical problems. People get into ethical problems because they're having problems. I want to talk a little bit about some of the problems that may afflict us as human beings that could inadvertently drag us across the line, a line that we, in the cool light of day when everything is going well, a line that we recognize that we would never cross, but that unfortunately sometimes amidst the fray and the heat of battle, or under the pressures of depression or financial distress or anxiety, we may trip and stumble and not know how to get back. That is, I think, more the problem that faces us in the modern practice. So let's take a look, first of all, at some of the context, and then I want to focus on these issues directly and give you, I hope, hopefully, some very practical tips and some new ways of thinking about problems that you may already have, but may not know exactly, one, that they're problems, and two, exactly how to deal with it. So I really feel as though I've been practicing now for 34 years. I know the feelings and the ebb and flow of anxieties that go with the practice, and I want to speak to you very directly about some approaches that may make your life pleasant and may keep you from having to worry about ethics, aside from, of course, getting the credits, which you need to have. So I'm thinking that if I go, do I point in one? Oh, there it is. Okay, so first of all, let me start off with the basic thing that I think will be helpful to think about. Now, in one of my incarnations, I am general counsel to the National Karate Federation. And I can tell you that rules aren't only important, they actually define a sport. For example, you can box, and there are certain techniques that are permitted. But you'll never see in a heavyweight boxing match someone grab the other person, trip him, throw him to the floor, and pin him. That's not boxing. We've now crossed the line to wrestling. In wrestling, boxing, once you get to grappling, they stop it. In wrestling, grappling is where it begins. Same with karate. Same with jiu-jitsu. There are lines, and they all define the sports. Ear biting, not part of boxing. Not part of boxing. Well, there's the things about our profession that make the rules, that define the profession in the same way that rules define a sport and tell you when you're boxing and when you're wrestling. It's important that you know that. Even when they have these, mixed martial arts and they have these, cage matches, there really are rules. I mean, you really can't go in with a gun and just, really, let's face it, I've taught karate, I've been a student of karate, and I can tell you, firearms will trump a pretty good blocking technique. This is clear. So, but in the same way, rules of professional conduct govern our conduct. They define our profession. It's a profession that's bound by certain principles, and these principles aren't a cost-benefit analysis. It's not like you can say, if I deliver a low blow, this will go and I'll win the match. No, that you won't win the match. You'll be disqualified. That doesn't count. Gouging the eyes? No, not a legitimate technique. So, in the same way, in our profession, there are rules. And there are certain things that are fouls. that are techniques that simply take us outside of it. So the fact effectiveness is not the way to determine whether an ethical rule is being followed. They are in fact mandatory, and they set forth a minimum level of conduct. I think that's important because in a lot of ways I think we know what's right and wrong, and if we simply actually listen to that rather than trying to find how many loopholes there are in the rules of professional conduct, we might be better served. So if you have a good gut and you have a pretty good sense of what's right and wrong, you probably won't run afoul of the rules of professional conduct. But if you get too clever by half and try to figure out ways around the rules of conduct, well, it's kind of like getting too aggressive an accountant under the tax laws. You know, you may end up with fines and penalties from the IRS. The RPCs don't set forth the disciplinary procedures. Those are set up for the rules of lawyer discipline, and hopefully you will never have to become familiar with those. The key, and this language was preserved. When I was on the Board of Governors of the State Bar, I fought to go and keep this language because I thought it was instructive. I thought it was helpful for my students at Seattle University Law School, and I think it's helpful for us. Each lawyer must find within his or her own conscience the touchstone against which to test the extent to which his or her action should rise above, that should say, minimum standards. Now, so let's just go and agree on some basic principles. The rules of professional conduct are minimum standards. Now, I recognize that some floors become other people's ceilings, but the truth is, if you do the right thing, you really won't be looking at the rules of professional conduct. If you're not sure, rule number one is feel free to confer with the Bar Association. Check with your colleagues, check the rules, but at the end of the day, if it doesn't feel right, don't do it. Now, if I can only get my youngest daughter to heed this advice, I would be, tremendous. I've discovered with my kids, have two daughters, now in their 20s. But I remember I was always very straight-laced, didn't do drugs, and I always thought, well, when I'm a father, and became a father, that this would give me tremendous credibility. I'd be able to tell my kids, don't do drugs. I didn't do it. You shouldn't do it. Because I thought it'd be a losing argument to say, well, I did it, and you shouldn't do it. I mean, that doesn't seem to happen. But I realized that it didn't work. My daughters in their teens, I'd say, well, I didn't do drugs. They'd say, yeah, Dad, you don't know what you're talking about. So you can't really win logically with kids, so that's another piece of just free advice. The RPCs don't tell you when you're liable for malpractice. An expert witness in a malpractice case has to testify what the duty of care is, and in fact, they're not permitted to refer to the RPCs. So malpractice is a completely different thing. You can breach the rules of professional conduct, and most of the time that will be some form of malpractice if it results in damages, but there are also times you can malpractice without violating any rules of professional conduct. For example, you can make a mistake. People are allowed to make mistakes. People are responsible for their mistakes. Doesn't make you an unethical person if someone charges you with malpractice. They're separate things. They're separate worlds. A lot of claims with the Bar Association mix these up. A lot of clients think that because they didn't like a result in a case, that means that you're unethical, but that's not the case. And if you ever have the misfortune of having a claim against you filed with the State Bar, and there's also a malpractice case, it is probable that the State Bar will simply defer to the civil litigation and not even reach the issue. Because, again, someone sues you for malpractice, that's for the courts to decide. It's not for the bar to decide. And as an attorney who has represented lawyers in ethical issues and also as a hearing officer for the State Bar, I can tell you that the State Bar has enough work to do without going and handling every time a lawyer makes a mistake and gets sued for malpractice. So that's not going to, there's an economy here that's at issue. What I want to talk about today that I thought might be a particular benefit is, in my experience over the years, not only as an attorney but as a person who was a hearing officer and who actually had the heavy duty of sanctioning, recommending sanctions, finding facts leading to the sanction of and disbarment of attorneys, and involved in the formal process of reprimand on the Board of Governors. I can tell you that these are the four horsemen of the misconduct. Drugs and alcohol, depression, financial stress and defalcation of funds, procrastination. Drugs and alcohol. Clearly, drugs and alcohol can be a response to depression. They can go and lead to further depression. They can lead to other financial stress can lead to drinking. Drinking can lead to depression. Financial stress can lead, whatever. And, it's any way you want to do it. I've come up with this way, but you can, trust me, you can try this on your own. You can do it in any order that you'd like, and anything can lead to anything else. But oftentimes what I would see in my experience was that someone would suffer from depression or anxiety. They would go and self-medicate with drugs or alcohol. They wouldn't take care of business. They would lead to procrastination and deceit because people would call them, what's happening, what's getting done, it wasn't getting done. They would feel like they had to go and perhaps dissemble with their clients. They would be found out, things didn't get any better. They would have financial distress because they couldn't get their bills out, which would lead to them not stealing, simply going into their trust funds just to cover a bill until they could go when this other thing came in and cover it again. I mean, nobody ever starts off with the idea that I'm going to steal this money. It always starts off with, I'm borrowing it. It's kind of like, I'm not going to go to sleep, I'm just going to take a nap. And it starts off like this. And then, of course, you get caught, you live in fear, you have further anxiety and depression. Now, this is a nightmarish cycle for any person. But let me just point out that this doesn't happen only to bad people. And one of the problems with ethics is I think sometimes we think that it's so easy. In the cool light of day, we would never be in that situation. But I'm here to tell you that if you're an attorney who is about to lose his home, or is facing a foreclosure, or you're underwater and you're facing a mortgage and you're sitting there with a trust account with money that, well, nobody needs it quite yet, or you haven't quite earned the fee yet. The idea of going and borrowing a little money to make it right, knowing, leaving an IOU in your mind and in the file that you're going to go and replace it as soon as possible, believe me, it is easier to get there than any of us would want to believe. It's just easier to get there, and some awfully good people get stuck in these problems. Now, I looked up, and I just confirmed on my iPad, which I've become addicted to, some studies involving the prevalence and patterns of major depression disorder in the United States labor force. And I found a further study in the Journal of Occupational Medicine, a 1990 article, Journal of Occupation Medicine, entitled article, Occupations and the Prevalence of Major Depressive Disorder. 100 occupations were tested, and lawyers had the highest rate of depression. The highest rate of any of the 100 professions. Highest. Woohoo! We're number one. This article written by Eden Mandel and Garrison, 32, Journal of Occupational Medicine, 1083, found the rate amongst lawyers. Let me tell you what the base rate is, just so you can appreciate this. Amongst all professions, according to the Journal of Mental Health Policy and Economics, the prevalence and pattern of major depressive disorder said this: recent advances in psychiatric epidemiology have made it clear that tens of millions of Americans suffer from major depression every year. Many are in the prime of their working lives. Now, I say this because some people in this room have depression. I'm not going to ask, and some people on the phone have depression. I'm not going to blame you, and I'm not going to go and ask you to reveal who you are. But I will ask for the people in this room a simple question and a simple evasion that I think you'll all be glad of, which is, how many people here have either had depression themselves or have a friend or family member or know of someone who has suffered depression? Okay? So if you can see the room, you can see that very many hands were raised, more than not. And so I'm going to work under the assumption that what I'm going to say to some of you will really be personally significant. I'm not asking you to reveal who you are. I'm simply saying, don't feel bad about it. Depression can happen to anyone. Biochemical condition. It can be treated. 80% of depressive disorders have some kind of neuropharmacologic solution that will make things better for you. And this cycle most often begins with depression. This cycle that we're pointing at here begins with depression, but it could begin at any place along that circle and go to any other point. I just put it that way because, well, I could get PowerPoint to do it, and it seemed like a good thing to do. So I want to go and suggest to you now that for those of you who don't have depression and are grateful and should be grateful of it, let me tell you that in the general population, about 12% of men and 18% of women of employed people have depression, major clinical depression, not just fleeting depressive episodes, which are even more frequent. But because we know that lawyers are of the most often suffer this, of the 100 professions that were written about, the estimates are between 25 and 30% of attorneys will at some point during their careers experience some form of depression. Now let me just say something about depression. Depression is one of those terrible things. It hurts, but it also afflicts the personhood of the person. It goes right for the person of the person. It's not like my arm hurts. It's like I hurt. And a person who has this situation and knows they're having trouble getting motivated, this may be combined with procrastination. Now, procrastination is something that many of us suffer from. This is a safer question, but let's just divide the world into two kinds of students. Students who get their term papers done early, students that pull all-nighters. Okay. How many of you were the students who got things done early? How many of you pulled all-nighters? I'm actually in both categories, so I get to raise my hand twice. This choice continues on through your legal practice. But this I can say about procrastination. There are two stages to procrastination. I tell my students this. First of all, you're facing a difficult challenge. You're not sure what to do. And then you figure out what to do, and then you implement that strategy. Okay, the time period between knowing what you're supposed to do and doing it, that's called procrastination. The time period when you're facing the challenge and trying to figure out what to do, that's called thinking. Now, the thinking part of it is good, up to a point, unless you're really procrastinating. You know what I mean. You know what you're going to do. Well, let me think about it some more, put it back. The clothes aren't quite dry. I'm going to put them in for another cycle. How many people do that when really what they're avoiding is taking the clothes out and putting them away? Wash them again, why not? Can't hurt anything. But seriously, we're in a time-sensitive profession, and sometimes the passage of time does hurt things and forecloses options. We're one of the few professions where at the end of a case, there is a perception sometimes as to someone wins and someone loses. Us and professional athletes. Very seldom, an accountant, I guess if the client gets audited, but most of the time, you don't see people holding up number cards when you leave, the architect. But the judge or the jury, they sometimes give you bad news. And this can happen. Or you get a decision that's unfavorable, and then this affects your sense of self-worth. And I think this is a factor that implicates why it is that sometimes we're depressed. Let's do a thought experiment. Let's say that we take a group of people who want to keep their options open, so they end up going to law school. Pardon me. So they want to keep your options open. You go to law school, and of course you're good students. Most of you are good students because you can't get in and out of law school without being a pretty decent student, which means that you have to place a lot of credit and give a lot of weight to external criteria of self-worth, such as grades. You have to, because you have to care enough about them to work hard to get them, and if it's completely meaningless and, hey man, what's the matter? It's not going to happen for you. So you're going to go and get good grades. They mean something to you. They're important to you. That means that you're already vulnerable and sensitive to being judged. Because remember, you're used to going and determining your success at the end of the course by some professor who, if he said he didn't like you, you wouldn't care. But when he puts a little number on a sheet of paper and hands it in, you care a lot. Maybe you were on scholarship. Maybe it mattered. But you're sensitive. You're primed. You're ready to be disappointed by the lack of success that you may meet in the world, and by objective criteria of self-worth outside of your own sense of, gee whiz, I did a good job. Somehow it feels better if someone gives you an A. And sometimes that person isn't your client. Sometimes the client is a bad grader. I had a client I spoke to the other day. He fired me and then rehired me, because things weren't happening fast enough. And so his one response to things is to keep on saying, well, it's been so many months. He keeps a calendar or something. Well, yes, but during those months we did this and this and this, and we're making progress, and the other side's agreed, and we got this order. And so, no, what's taken so long? Well, so we all face this. Unfair grading. Judges that make mistakes. Sometimes we're on the wrong side of a tough issue, uphill, the downhill side of an issue, and that happens too. But at the end of the day, we have a psychology, a psyche that is vulnerable to judgment by these external criteria. And so I say this to you simply to let you know that if you lose and clients say mean things to you and you're not feeling appreciated, yeah, you could get bummed out. And this could kick you over into a cycle of anxiety, feeling inadequate, and depression. Now, there is help for you. And I just want to let you know that this happens so often that the only thing I can say to you is, first of all, you're not alone. Okay, so if that makes anyone here feel better, then that may be a good thing. Because there are a lot of information you've gotten today, but how many people actually told you something and made you feel better? Maybe this is the first one. Congratulations for me. Okay. I'm giving myself a good grade. Okay. So you have a situation. Now, how many of us, apart from depression, do periodically have a case that simply isn't getting attended to? It's the runt of the litter. It's the case that if there's anything else to do in the office, including freshening those flowers over there, you're going to do that before you're going to get to this case. Has anyone ever had a case that just, you don't like this case doesn't like you, it's star-crossed, it's not going to go well, the client's not particularly nice, you don't like, it's like getting into a wet bathing suit every time you look at the file. Has anyone ever had a case like that? Raise your hand. People on their phone, you can raise your hands too, and we won't know you or acknowledge you.
Well, we have 3 people raising their hands.
3 people on the phone raise their hands. Oh, okay. There it is. Excellent. Thank you for raising your hands on the phone. Why are you raising your hands on the phone? Okay. So, in any case, so we have these cases. So what's the solution? I'm going to give you a practical solution. A practical solution. Here it is. First of all, let's ask ourselves the question. Let's go and make a note of that case that we're having trouble getting to. Let's just simply talk to ourselves and be honest about it, saying, I'm having trouble with this case. Now, you know what? It is okay to periodically cull the flock. I used to, I know you're thinking, how can one guy wear all these hats? I was a shepherd in a previous life. Sometimes you have to get rid of some of your sheep. It's okay for you to go and be honest and say, you know what, I don't think I'm the right lawyer for this case. I'm not feeling comfortable with the facts. I'm not feeling comfortable with the law. I'm not feeling comfortable with the client. I can't seem to get to it. I don't like working on it. It's okay. And it's okay to bring in another attorney, associate another attorney, do a regular review in your office. If you have other lawyers in the office, say, listen, I'm having trouble. I'm having trouble with this case. I'm having trouble getting going, knowing what to do in this case. I'm here to go and give you one solution that is absolutely true. There's nothing that you have to do in the practice of law. There's nothing that you have to do in the practice of life that cannot be broken down into smaller pieces. There's nothing. Think about that. What a relief that is. You don't need to get it all done. You can simply say, I need to go and put on your little, say, tomorrow I'm going to spend 15 minutes looking at this file. Or I'm going to spend 20 minutes speaking with someone else about this file. Or I'm going to call someone and ask them their advice about this file. Just move it along. Ask for help. Ask for help from others. Now, if you're in the grips of a major depressive episode, asking the help of others is a really good place to start too, because you'll discover that almost everyone knows someone who's been through this or has been through it themselves. So you should know that the Lawyers Assistance Program at the Washington State Bar Association has some help available to you on a confidential basis. It doesn't count against you. They don't take the information, write notes on you, and hand it to disciplinary counsel. No, that happens later when you screw up. But at the early stage of self-recognition and self-correction, you're doing exactly the right thing. You're like the person who is, if you will, had too much to drink, and they're calling a cab. That is the right thing to do. Telling the officer that you're not under the affluence of alcohol is not the right thing to do. Okay. So I wanted to talk about this specifically because these are issues that I think are really important. So what is the basic thing I've told you? It's what I've already told you. First of all, you're not alone. Second of all, there are ways and simple techniques that you can use. If you're in an office and have colleagues, do a regular round table and make sure that on the list of that round table or in your own review or with your staff member or with a colleague or friend, just go and arrange to sit down and say, I'm having trouble getting going on this case. Everyone's had that trouble. Everyone has had some, how many people, raise your hand, how many people have had trouble with some case they're just having trouble getting started on getting it done? Is there anyone who here is a liar? No. Some people are just self-motivated. No, seriously.
Well, I just heard a tip from a lawyer at a CLE giving a presentation about this, and it was really kind of helpful advice.
Sure.
Just if you have that case, you just don't want to open that file, it's just bugging you, you're just trying to avoid it, just do it first. Just put it first in the day when you don't have anything else on your mind, and usually you can address that difficulty far faster than you ever imagined. And
I think that's good advice.
That's good advice.
Let me ask this question, and we'll have the microphone brought over. Is there anyone else who has found a strategy that worked for them on dealing with this kind of situation, what I'll call the getting back into the wet bathing suit situation, where you have that case that's just difficult? Anyone found some technique that worked for them? Because I want it to be okay for us here and with our colleagues to be able to acknowledge that, yeah, if we have 1 in 3 lawyers or 1 in 5 lawyers or it's between 1 in 5 and 1 in 3 lawyers suffering from depression and suffering from challenges to getting things done, we probably ought to spend maybe, more of our time than the last hour on a long day talking about it. Anyone else have any? Please offer them if you do, because I'll be glad to have your input on this so that everyone can get the benefit of our collective wisdom. Because collective wisdom is what makes us strong. People have wrestled these problems and solved these. You don't need to reinvent the wheel. Now, I did want to spend time on this, but I feel as though I think that what I want to do is give everyone permission to recognize that we are all more at risk for these things, that the 1 hour of ethics is not for the other guy. It's for us if we stumble. And we all are capable of stumbling. We all may have in long lives and long careers stumbled and learned how to make repair. And I think that's important too. So I want to move on and give you some more information, but I want you to keep in the back of your mind the idea that if you do encounter any of these problems, the Lawyer's Assistance Program, speaking to friends, being honest with family members, opening up and getting that support can be an important first step, as well as therapeutic intervention. You know, some people's lives have been changed by the right pharmaceutical product, and don't feel less than if you find that every once in a while we need to go and give a kick to your neurochemistry to get you straightened out, because you'll feel so much better, according to those who have gone through this experience. You'll feel so much better that it will be well worth any possible embarrassment that you might feel on a transient basis. Just, I'd say, get over the embarrassment and get to the solution and move on, because the energy you'll get will be, and happiness and joy and renewed joy you'll get would be a tremendous benefit and keep you from running into this kind of downward spiral. Now, I want to talk about discovery obligations, and a lot of people are confused about discovery, because I think it's fair to say that to presuppose that lawyers will comply with rules which they regard as being duty-bound to stretch to the breaking point is probably an unsound theory. And so, you know, everyone thinks that, gee whiz, I am a fierce advocate. I'm going to go and get a good result for my client. Is it okay if I save millions for my client to receive sanctions from the court? I'll be fined a few thousand, save my client hundreds of thousands of dollars. All I've done is keep a document that revealed the true value of an asset, hidden it someplace in my briefcase, and dithered for long enough over whether really it was asked for in the interrogatories. In the Fison's case, which I've attached an article I wrote about that, you'll see that there was a question asked, does theophylline cause brain damage? And apparently in that case, the defense counsel that was responding found every single word in that sentence to be ambiguous, except for the word does. Theophylline, well, do you mean the generic or the actual? Cause, well, cause, indirect or direct, you know. Brain damage, or well, central nervous system or peripheral damage. I mean, everything was ambiguous. They couldn't figure out anything. What is a brain? I don't know, you know. So we have to go and get past the notion that some kind of ethic arises, something positive emerges from the idea of being this warrior. This warrior business, look, you know what? Being a warrior isn't everything it was cut out to be. The life expectancy isn't good. The job security is worse. Really, warrior? Is that really the role model that we want to have? Warrior? Some guy who doesn't get to shower for a long time, sleeps outside, and goes and bleeds a lot? Not me. I'm not a warrior. But I am a counselor, I am an advocate, I'm a lawyer. But warrior, I think that's one of these self-aggrandizing kinds of things. Warrior. Everyone's a warrior. Everyone's a hero nowadays. Let's just try to do our jobs, okay? Okay. Let's not get too full of ourselves. But it is true that in family law, you're advocates for people, and you need to make them feel safe, and you need to be more sane than your clients, which is a low bar. Because you're dealing... No. Let's be fair. Anyone who's represented people going through this terrible, worst stage in their life, or anyone who's gone through it themselves, knows that sanity is a theoretical state of mind that applies to people who aren't dealing with that rotten person who do it. No. I mean, you don't understand. You can't know what I'm... You know, I mean, yeah. So, I mean, there's an awful lot that we have to absorb in our buffers. And we need to be saner than people who are at the worst time in their lives. Okay, they've got an excuse. Every day we show up, we're dealing with, in some cases, the worst time of a person's life. Now, that's a tremendous gift and opportunity, but it's a tremendous burden and challenge, too, isn't it? I mean, you know, really, buck up. You know, really? Really? That's what you got for me. That's the best you got. Okay. So, it is easy sometimes when you see wrongdoing in the hands of opposing counsel, and this does happen, where people go and hide. I've often wondered, why do people why do they just not answer interrogatories? Why don't they just, if they're really going to be unethical, why don't they go the whole distance? Why don't they just create fake interrogatories, call actors as witnesses, and get, carve out my firm's stamp on a bar of soap, and, why don't they just go the whole way and do full-fledged fraud? In the East Coast, that's what they did. They had hundreds of millions of dollars pass hands because they had fake accidents with fake victims, lawyers on both sides, fake doctors, fake drivers. It was everything. It was great. That in New York, they know how to. Well, I'll tell you, that's where I'm from. That really, really, fraud. Come on, you pikers. Come on, get in there. But seriously, so we have this discovery. I want to go and tell you something that I've checked with a majority of members of the Supreme Court in conversations I've had with them. What I'm telling you now is not from the ivory tower. This is the real world, and I think it will give you some peace. I want to tell you something about discovery. So the question is it okay? Is it okay as an advocate to hide documents? Let's just take the simple case, or delay them. Now, we all know the right answer. The right answer is no. But why is that the right answer? Well, I'm going to show you. Because we know it's very effective. It's like war crimes. It's hard to detect because the information is in the custody of offending parties. So if someone's hiding documents from you, how do you know if they're hiding them? Maybe they just couldn't find them. The rewards are great. It is effective to hide documents. It's hard to get judges to pay attention and to enforce this because it's unpleasant. They said so in written opinions. The prosecution, they don't like to go and say, this is what happens. You go in and say, he's hiding documents, she's hiding documents. And they say, can't everyone just get along? Yeah, we can get along if he produces the documents. The fact is there are people who are cheaters. And the question is, what do you do in response to someone who's cheating? Well, the answer is not a race to the bottom, I'll cheat too. That can't be the right answer. You have to be absolutely scrupulous because it encourages otherwise the lowest level of conduct. Now, you're a member of a profession. We have these rules of ethics. You're spending an hour here listening to it, and you're going to get you 1 hour of credit. I want to give you your money's worth. So how do you go and reconcile being a person who's a member of a profession governed by ethical rules and at the same time being a person who's an advocate for a client in an environment that seems so adversarial that you're having a hard time getting the documents out of the other side? Well, first of all, here's the answer. But first I need to tell you a fable which is based on an imaginary Olympics. So let's say you have an athlete who hides the car keys of the competitors so they can't get to the stadium on time. But just to go and flesh the story out, they don't only hide the car keys. They go in many different languages, issue notices changing the venue. So the people go to the wrong stadium or the wrong place, they get stuck in traffic. And just to ensure things, they, take the distributor cap or disable the other person's vehicle in some manner. And then they show up at the stadium unopposed. They win the race, and they stand there alone with the gold medal saying, I am a fierce competitor. Now, clearly, we all recognize that's not... You're supposed to run fast in the stadium. The competition doesn't mean running a sound truck around the dormitories keeping your opponent up all night. That's not part of the competition. So that's what's wrong with the picture. Well, here's the answer. Discovery is not part of the adversary process. Now, say that to yourself. A lot of you probably think we're in an adversarial process. I know that there's an element of collaboration that's coming into family law practice. In appropriate cases, collaborative law can work if the conditions are right. But you're never going to get collaborative law between an abuser and an abused party. You can't mediate that. They're an unequal party, unequal power. So if we're left with a process that's adversarial, you have to understand the discovery of information is not adversarial. Now, I checked this with some Supreme Court justices. I've read all the cases on this. I've been teaching it for 13 years. Nobody can convince me that, you see, this is what happens. You get all of the information together, and you both go and contribute to that pile of information through discovery. And then each of you looks at that pile and pulls out the facts that you like, and you argue the merits of the case based on your inferences and turning the facts as best as you're able. Some people's facts aren't as good as others. We call those people the non-prevailing party. And I always tell my colleagues and students, I always say, you know, sometimes in spite of our best efforts, a case is decided on the merits. Regrettable as that may be. And so really, let's just remember that we're part of an ultimate truth-finding, justice-seeking process. But just to make it easy, discovery is not part of the adversarial process. You get to advocate as much as you can. You don't get to hide documents. That's called cheating. That's running the sound truck around the dormitories. That's, you know, that's cheating. That's not part of the rules. That doesn't make the system work, and it cannot work that way. So when you're answering interrogatories, recognize that sometimes you're going to be answering things and saying things that aren't going to help you. But you got to deal with them because they're true. And that's just the way it is, because the system really can't work with both sides lying with all their might. I'm prepared to go and answer any questions about this. I know some of you have dealt with adversaries who aren't as scrupulous, perhaps, as you are. But here's the thing. Don't follow them down the rabbit hole. You just do your facts and let some brand X lawyer do his facts. Ultimately, your credibility and integrity and your willingness to be forthright with the court will become evident. Because, you know, lying actually takes a toll on you, and it makes you less credible. The only thing we really have to offer as trial lawyers is our own credibility. That's what Aristotle would call ethos, as opposed to pathos and logos. Pathos appeal to emotion, logos appeal to logic, ethos the force of your personality, your personhood. Don't damage that in the paltry pursuit of gain in an individual case for a client who won't know you as soon as you send the bill. I want to talk to you about one gentleman. It's a public record now. This is a July 12, 2012 decision. I've appended it to your materials. It's brand new. This is a brand new case. Traditionally, we thought that, gee whiz, if I mess around with discovery, the worst thing that happens is someone, possibly my client, gets sanctioned. But in fact, this lawyer managed to parlay it into an 18-month suspension. Granted, he augmented his lack of cooperation with discovery by making disparaging comments about ex parte to the judge about the opposing party, who was, surprise of surprises, Canadian. And so he basically said, Your Honor, you shouldn't go in favor of this Canadian, you know, they're just taking American jobs. Well, really? Really? Is that a good argument? Ex parte? Well, the judge turned him in. You should read this. Of course, he failed to respond to discovery requests. He failed to respond to basic requests even after the court ordered him to do so. And the court came to the conclusion that, you know what? It's not that this guy doesn't get it. It's that he's not going to get it. We need to thump him. And he just gave boilerplate answers. This is a case that you should know about. If you see someone really violating the rules, I don't say that we should be throwing and hurling claims against each other. I simply think we should all be aware of the fact that the conventional wisdom that no matter how badly you behave in discovery, that is not going to lead to a disciplinary matter, that's not so exactly. You can go and, if you play it wrong, you can actually behave badly enough that your license can be imperiled. 18 months. Now I want to talk about a case that came out of Michigan, misconduct during depositions. We've seen it. We recognize it. Here it was determined the counsel, and I've attached this also as an appendix to your materials, Appendix B to my materials. Counsel tactically engaged in commentary and actions to provoke, intimidate, or belittle opposing counsel and their clients. They found he was sarcastic, insulting, condescending, patronizing, and rude. Now think about that. That's better than the trifecta. I don't know how he's done it, but this is like the decathlon, the pentathlon to be accurate, the pentathlon of bad behaviors. These tactics in no way further the interests of his clients. Appendix B is worth your review, particularly the findings. It makes some amusing reading. Let me just read some of the selected segments. He insulted and belittled opposing counsel, calling him a nitwit. Told the client, the other guy's client, you should hire another lawyer. Told the opposing counsel to be quiet and shut up. You just button it. You want to be spanked? You've been real good sitting there, not saying anything and knowing your place in this deposition. You just sit there and be quiet and enjoy the ride while we're over here talking business. Now, look, it is possible for a person to cross the line, and I'm speaking now specifically to younger attorneys and particularly, I think, maybe to women attorneys. It is possible that some troglodytes from the Neolithic times think that they can overbear people and harass and abuse and intimidate and maybe even use physical size and whatever to try to go and get some kind of litigation advantage. I want to let you know that a lot of judges in King County are prepared for this, and that you can actually get a direct line to some judges who will go and actually intervene in a deposition right then and there and make rulings if someone's being abusive and intimidating. Some judges resolve discovery disputes, and they'll make special time because they know it saves them a lot of motions that they don't want to read. And federal judges too, though you may be more often in the state courts, of course, in family law matters. But some of us have met with such people. These people it's kind of like road rage. The way I figure it, folks, we're all doing therapy. It's just some of us do it in a little room with a qualified professional, and some of us do it on the highways, or the courtrooms, or the conference rooms where depositions occur. When you see people like this, you should think what I think. You should say, this guy's working out some deep issues. Right? This guy's got issues. And you should not rise to the bait, and you just have to go and just I think some perspective and speaking to colleagues is important. The Civil Rule 30H6 describes that there's a courtroom standard for conduct in depositions. Now, in this case, this attorney who in Michigan was sanctioned for this deposition conduct was supported by a judge who had a good reputation, and the court reviewing it simply said, you know what? Apparently the respondent is a different person when the judge is present than during the deposition. This testimony supports the finding that the respondent's deposition behavior was tactical. The fact that a person knows enough to go and be polite to a judge, you know what we call a person like this. What do we call a person who goes and kisses up to authority and abuses people who are perceived as smaller and less powerful? We call this person a bully and a coward. Unfortunately, how many of you have experienced a deposition where you felt opposing counsel went over the top in a way that you felt was truly trying to use bullying tactics to try to gain litigation advantage? Okay. So this is a problem. There are solutions to this problem. One of them is, of course, not to lose your cool. Let me just tell you, my solution to almost everything in the world is don't give to the other side that which they can only get if you give it to them. They can't take your cool. You have to give it. So use the techniques. Breathing is good. In through the nose, out through the mouth. In the martial arts, very important, because we discover, you know what, I teach my students this also. I say, you know what, one of the basic rules, people don't know how to breathe. You know, we do it 17, 18, 19 times a minute. We don't know how to breathe. The fact is, I'll teach you this after the session. In question and answers, I'll tell you how. But basically, the first rule of breathing is, you cannot breathe in until you've breathed out. Try it. You can do this on your own time. So seriously, maintaining self-mastery. Now, Carlos Castaneda wrote a book called The Fire Within. And in it he said, no person can achieve true self-mastery without being first subjected to the tyranny of a petty tyrant. The tyranny of a petty tyrant is oftentimes what we have experienced sometimes when other lawyers get abusive, where they're acting out their issues, where their client's issues seems strangely personalized. It's kind of, you know what I mean? They can't be this exercised about the legal issue. You know, it's just got to be something more. They're acting out something from their childhood, and I'm not skilled enough to get there in this therapy session / deposition. So we have to go and maintain our self-mastery. Now, I say this with a smile, but the truth is, you know what I'm saying is right. The fact is, you can't rise to the bait. If you find a person who has that characteristic, you must be firm, you must be respectful, and you must be prepared to adjourn the deposition and trot it out before a neutral audience. There's no reason why any lawyer should be trembling with fear or shaking with or afraid to go to a deposition with opposing counsel because of a level of indignity or personal assault on them. That is not right. You should not put up with it. And if I haven't come up with all the solutions, but seriously, it should not be permitted to continue for any reason. This is not passionate and engaged, as the court found. It was tactically sarcastic, patronizing, insulting, intimidating. It's prejudicial to the administration of justice. The person was sanctioned. Here's a bright line rule that you should avoid. 26.09160 says that an attempt by a parent in either the negotiation or performance of a parenting plan to condition one aspect of the parenting plan upon another, to condition payment of child support upon an aspect of the parenting plan, to refuse to pay ordered child support, or to hinder the performance by the other parent of duties shall be deemed bad faith and shall be punished by the court by holding the party in contempt. You mustn't ever, of course, get into a situation where you're saying, well, if you want this for the kids, then, no log rolling. Maybe in the legislature, but not when we're dealing with kids' rights in a family law proceeding. I know you're familiar with this, but it's a bright line, and it's one worth recognizing so that you don't run afoul of it. Ultimately, I'd like to simply say that there are 4 tiers that lawyers must aspire to. Only once in my career, ran into a lawyer who was at the lowest tier, self-interest. He would go around, literally, he would go to a dry cleaner, and if the dry cleaner, would turn over his clothes, he would refuse to pay him, threatening him with a lawsuit. It'll cost you more than he was a legal terrorist. He was a legal terrorist. He had other issues. I had an occasion to. He was a co-counsel in a case, and in that case, 24 clients got together and they all fired him in the same day because he was undermining a settlement because of his own personal issues. I couldn't, of course, I just said they had the right to have counsel as they wanted and so forth. Some years later, someone called me on the phone and said, boy, you were really right about that. Guy said, right about what? I said, well, did you see the papers? I said, well, no, what's it? Apparently, the same lawyer was found, basically a short story. He was arrested trying to arrange an assignation with a 14-year-old female in a hotel room in Portland because apparently there was this somewhat hirsute mid-40s FBI agent named Gill who did a good job of impersonating a 14-year-old girl on the internet, and he proceeded with a plan that was illegal, and there was OxyContin found, and all sorts of issues, chains and stuff. Anyway, he's no longer a lawyer, in the state of Washington. But so there are people who are at this low tier. They're remarkably few, and they are basically of a criminal bent. Simply following orders is oftentimes a lot. This is what my client wants. Well, no. Just what your client wants, being an empty receptacle into which is poured every obscene wish of your client, is not exercising independent professional judgment. You're not a receptacle that is able to hold things of any size and shape. You are a person, you have integrity, you have values. There are some things that are wrong. You shouldn't do them. You just don't follow orders. You're a lawyer. You're not a tool. That falls beneath the standard of professional conduct that's required. The minimum standard of conduct on this chart is the third one down, which is actually, if you will, the third one up, which is exercising independent professional judgment. You'd be amazed at how much your clients respect you when they discover there are things that you will not do. You've probably heard the joke about the why scientists are using lawyers rather than white mice to do experiments, because there are some things that white mice won't do. Or I think it was rats. But in any case, you get the point. I don't like lawyers' jokes, so I've spent much of my career combating them and not laughing at them. And I've discovered that if you simply don't laugh at a joke, the other person kind of changes the subject. So what I'm going to recommend to you is, do please follow your independent professional judgment. Take pride in the fact that you get to do that, and take pride in using the word no occasionally when a client wants you to do something which you find to be repugnant or reprehensible. That is not only what you ought to do, it's not only the ethical thing to do, it's what you're actually required to do. You must use your judgment. And I know that's hard to do when sometimes you need the paycheck. But trust me, in the long run, letting the lawyer know that they can go down the block to Brand X lawyer and have XYZ done, and there are things you will not do, that's okay. That's okay. And that's not a bad thing for your reputation. In the end of the day, I think what we should all aspire to do is to bring out the better angels of our nature, and the nature of our clients as well, who are going through very difficult times. Try to find solutions that are enduring, things that will actually work for the people and for the kids involved. Try to go and get something that not only sits right with the legal system and the rules of ethics, but that sits right with you. Because you know what? At the end of the day, you're going to spend a lot more time with you than you're ever going to spend with any client. And it seems to me that the person you ought to be pleasing at the end of the day is you. That person in the mirror, that person that has a life, that person who has family and who has children or friends or loved ones that you need to live up to. You know, we're in a great profession. We're in a much better profession than almost any other profession I can think of. Dentist? You're kidding? What a job. No, much better to be attorneys. And we have a great opportunity to solve social ills and to make the world a better place and to feel good doing it. There are certain rules we need to follow, and if we simply remember those rules and follow the rules of the road, I think you can have a satisfying profession for many years, feel good about what you do, and feel the pride in what you do that I feel in being a lawyer. Thank you very much. And I think